So I submit that the rationale for the arms acquisitions was illegal, unconstitutional, and fraudulent right from inception. Given my expertise gained as an international banker with Nedbank, I make the submission that the arms deal was also fraudulent.
Okay. Will you kindly inform the Commission as to what is the basis of this statement that the acquisition was illegal, unconstitutional, and fraudulent right from the inception?
I base the proposition on Section 2171 of the Constitution, which sets out that government procurements must be conducted in accordance with a system that is fair, equitable, transparent, competitive, and cost-effective. So it follows from that.
Right, I think your basis is developed further later in your statement. And for now, we leave it as it is, and then you deal with it
Yes.
more in detail.
Yes.
To reach the point. Will you then proceed to the next paragraph, 1.2?
Thank you. Contrary to assertions by admirals, generals, and officials in the earlier round of hearings, the real rationale for the arms deal was not the need in the post-apartheid era to replace obsolete warships and warplanes.
Now, here you are touching on the evidence that has been presented about the reason why the acquisition was done. And in your statement, then you say the need was not the real reason for the acquisition. Now, bearing in mind the evidence that was presented by the admirals and generals about the arms acquisition and steps that were taken preceding the acquisition, that defense white paper, that defense review, and there was also reference to even the defense white paper of 1984, where from as far back as then, a need for the acquisition of armaments, especially within the Navy and the Air Force area, was iterated. Now, bearing that in mind, can you just explain to the Commission as to what is the basis of your statement that the rationale was not the need for the acquisition in order to replace the obsolete warships and warplanes that were something else, and maybe even state further as to what was the motivation, that was not the motivation.
Yes, the emphasis during the apartheid era had been primarily on the army, and vast amounts of money had been squandered on that, together also with nuclear weapons. So South Africa was hugely overarmed relative to our neighbouring countries, particularly in respect to the army. The Air Force equipment had become increasingly obsolescent, as had the Navy equipment. But as was conceded during the Defence White Paper, there was no conceivable foreign military threat to South Africa. We were not under threat from the Soviet Union or Russia or China or the United States. The threat was internal, it was a question of poverty, and that was the emphasis of the Defence White Paper.
Now, still on this point, when one looks at the defense review as well as the white paper, there is, as you rightly point out, that the main concern was about socio-economic issues. However, that document, the defense review, goes on also to talk about the need for the protection of the sovereignty of the country. And it goes on to elaborate on different categories as to what the paid by the SANDF within the region on the international stage, as well as what the armaments can be used even for local benefit.
Mm-hmm.
Now, bearing that in mind, and this history that is there since when it was established that the armaments have become obsolete, what is the basis then of saying that the purchase was not motivated by need? Maybe the correct question to ask now is, what, in your view, motivated the need for the acquisition other than the need to replace obsolete armaments?
Even before the transition, the Navy was anxious to acquire new vessels, and they were called corvettes at that stage. And it may be recalled that in 1994 already there was a proposal to buy 4 corvettes at a cost of 1.7 billion rand, and there was competition between Spain, Britain, Germany, France and Denmark. The decision was almost made to buy 4 Spanish corvettes at a cost of 1.7 billion rand, and Spain was going to provide, as I recall, 4.8 billion rand in offsets, which was to be split between increased imports of South African coal and increased imports of South African fish. They were going to provide 30 trawlers and build 2 huge fish factories on the Cape coast that would create 23,000 jobs. There was huge public uproar about this, marches to Parliament and so forth, people saying we want houses, this is our priority, we want houses. I was able to send some of the proposals regarding the fish factories and the fishing suggestions and offset proposals, and they were still called counter-trade at that stage, to the managing director of one of my former clients with Nedbank. And his response was, there is just not enough hake in South African waters to cope with this huge demand from Spain for South African fish. It will destroy what remains of the South African fishing industry, which then employed about 85,000 people. So in return for creating supposedly 23,000 jobs, we were going to destroy an industry that employed 85,000 people. So the Spanish corvette proposals were abandoned in June 1995. In a meeting I had with Mr. Modise, he conceded that yes, that analysis had been correct, and that they would not make the mistake next time round. I think that was early '96. Suddenly we're going from 4 corvettes at a cost of 1.7 billion into 4 frigates, which were very, very considerably larger. A corvette runs from about 500 tons to 2,000 tons, so now we're buying frigates at 3,400 tons. Plus submarines, plus fighter aircraft, plus at that time tanks. And it became, it was covered in due course in the Defence Review as in terms of various core force options. And as I recall, core force option number 1 estimated the cost would be about 6.9 billion rand. So we'd gone from 1.7 billion to 6.9. Then various other things got added, and before we knew it, we're up to 30 billion.
Mr. Brown, what I'm trying to get from you that will assist the Commission is...
I'm sorry, Ms. Wong, can you talk go closer to the machine? We are struggling to hear.
Right, thank you, Chair. Mr. Crawford, what I would like you to assist the Commission with is what, in your view, was the real rationale for the arms deal? Because in this paragraph, what you are stating is that the acquisition, the arms acquisition, the rationale was not for the replacement. Now, what do you say the rationale was? Because this statement just says this was not the rationale. So what was the rationale?
Okay. If the rationale for buying 4 Spanish corvettes in 1994 had been we'd spend 1.7 billion to get 4.8 billion back in counter trade, which became offsets, the rationale evolved that we would spend 30 billion rand to get 110 billion back in offsets, and that would create 65,000 jobs. And so again, it was the offsets that drove the acquisition process rather than the actual need for equipment. The more we spent, the more we would get back in offsets.
I will invite you to proceed to the next paragraph, because I think you deal more in detail with the offsets later in your statement.
Thank you. As I say, in contrary to the assertion of the generals and admirals, instead in substantiation of my contention, the Commission's senior evidence leader, Advocate Tayyub Abubakar, in his opening address on the 20th of January 2014, quoted as follows from the former Minister of Defence, the late Joe Modise's budget speech to Parliament on the 9th of March 1999. Quote, "In return for our expenditure, our economy will benefit by an estimated 110 billion rand of new investment and industrial participation programs and the creation of approximately 65,000 jobs. The skeptics have suggested that this is wishful thinking. The following breakdown has been very carefully calculated with the Department of Trade and Industry. Of the 110 billion rand, over 26 billion rand is made up of direct investment into the project. 25 billion rand is estimated revenue from local sales stemming from the business projects that will be established, and 59 billion rand will be derived from export sales." Unquote. Advocate Abubakar continued, quote, "On the basis of Mr. Modise's address to Parliament, the expectation raised was that the economy would benefit by 110 billion rand of new investment and industrial participation programs, and that 65,000 jobs would be created. What was actually delivered by the SDPP in terms of said offsets and jobs has therefore to be tested against this benchmark."
Now, this paragraph 1.3 of the statement is actually dedicated to a quotation of Advocate Abubakar's opening, part of the opening address. That is what it is. Right. Thank you. You may proceed to the next paragraph.
Thank you. I repeat that final sentence. What was actually delivered in terms of offsets and jobs has therefore to be tested against this benchmark. Now, predictably, the offsets did not materialize, as the Department of Trade and Industry now concedes. The whole process, I submit, was fraudulent, and so everything else, including the bribes, is simply mere commentary to illustrate the point. But the offsets were, I would suggest to the Commission, was a fraudulent process as well as being unconstitutional. Now, my written submission...
That's before you proceed to the next paragraph. On paragraph 4, you see, in conclusion, the whole process was fraudulent. Everything else, including bribes, is mere commentary. Now, I'd like to draw the attention of the Commission to this statement that says the whole process was fraudulent. Will you please explain as to what is the basis of that statement?
The idea that if you spent 30 billion, you'd get 110 billion back and it would create 65,000 jobs. Offsets are internationally notorious as a scam promoted by the international armaments industry towards weapons proliferation, and the history of offsets is that they do not materialize.
Mr. Chairperson, maybe before Ms. Ramahaka could continue with the reading of the evidence of Mr. Prophet Brown, just one idea, Mr. Prophet Brown saying that the DTI has conceded that actually the NIP didn't materialize. I don't remember such a statement made by the DTI that the DIPS or the NIPS did not, there was never such a concession.
Thank you, Mr. Chairman. Can you reserve that question for your cross-examination? You all get a chance to cross-examine if you so wishes. Just make a note of it, and you can raise it with Mr. Crawford Brown at the later stage.
Thank you, Mr. Chair.
Thank you.
Thank you, Chair. Yes, Mr. Crawford Brown, will you please respond to that question?
Yes, it is a point that will be canvassed later, traversed later with the DTI audit report that came out earlier this year, and that the offsets had failed the various requirements even of the DTI, and that we hadn't received the jobs. There's a thought that we might at best have got 6,000 jobs, but even that's only an estimate.
So what you are saying is that the submission that the whole process was fraudulent will be addressed later in detail when you deal with the topic that relates to the offset.
That is correct.
Now, will you then proceed to the next paragraph, sir? Paragraph 1.5.
Yes. Yes, my written submission to the Commission made in June 2012 includes a 12-page legal opinion regarding offsets by Advocate Jeff Budlander that I commissioned immediately after the Commission's terms of reference were established in 2011. It was appended as Exhibit A, and Advocate Budlander's opinion finds that offsets fail the requirements of Section 2171 of the Constitution regarding government procurements. In his conclusions, Advocate Budlander declares the procurement contracts in the arms deal were required by law to be in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. In the system which was used in these contracts, offsets played a very material role. There is reason to doubt whether such a system is in accordance with those requirements. If the contracts were not in accordance with those requirements, they were unlawful and invalid. Whether such a contract will be set aside by a court depends on the facts of the case. If the contracts were marked by bribery or other improper conduct, a participant in the corrupt arrangement cannot receive or retain any of the amounts payable under the contract, unquote. Given Advocate Budlander's legal opinion and his high standing and reputation in legal circles, I contend that the arms procurements were illegal and unconstitutional because they did not comply with the constitutional requirement of a system which is fair, equitable, transparent, competitive, and cost-effective.
Now, I'd like to invite you to pages 111 to 122 of the bundle, where, Commissioners, you will find the opinion that the witness is relying upon for the argument in support of a challenge or an attack on the acquisition. Now, that appears 111 to 122. in particular, I'd like to take you to page 112, paragraph 3. Page 112, paragraph 3. Now, the last sentence in that paragraph says, one of the key points of the focus of Mr. Crawford Brown's complaints and also of the subject matter of the Commission of Inquiry is the offset agreements which formed part of the contract. And paragraph 4 says, I've been asked to advise on the legal validity of the arms deal in the light of the provisions of section 2171. Now, is it correct that in terms of the brief that you gave Advocate Butler, the key issue that you were raising there was the use of the offset agreements?
That is correct. I would submit that 3 of the 6 terms of reference of the Commission deal with offsets: the rationale, the jobs, and the technology.
And the brief that you gave was to advise on the legal validity of the arms procurement in the light of the provisions. I'll prefer to use the word procurement rather than deal, but here and there I may still use it because I'm reading like the arms procurement. Now, it says he has been asked to advise on the legal validity of the arms procurement in the light of the provisions of section 217. That is actually the brief that you give.
That is correct. And my whole submission is really focused on section 2171 regarding government procurements.
And in paragraph 5 of that opinion, there is actually quoted from the Constitution about the requirements that the system must be fair, equitable, transparent, competitive, and cost-effective. Now, is there any basis upon which you state that the acquisition process was neither fair, equitable, transparent, competitive, nor cost-effective? And when you respond, I'd like you to request that you deal with each of those elements separately.
If I may. That's not it. Thank you. Focusing on these 5 issues. Focusing on these 5 issues, I would suggest that all the arms deal contracts are invalid for want of compliance with section 2171, in that 1, the procurement contracts were not fairly concluded because of the socio-economic needs of South Africans, which militated against vast expenditures on unnecessary armaments. The 1996 Defence White Paper, which preceded the acquisitions, had noted there was no conceivable foreign military threat to South Africa, and that given the heavy militarization of the previous apartheid era, priority must be given in the post-apartheid democratic era to poverty eradication. Secondly, the procurement contracts were not equitably concluded because the tender procedures were manipulated to arrive at a predetermined conclusion by inter alia adopting a visionary approach to reach their conclusion. In the visionary approach applied to the BAE contracts, for instance, cost was excluded as a factor for consideration. Thirdly, the procurement contracts were not transparently concluded in that lower tenders were ignored in favour of backroom bargaining, unnecessary middlemen, and irregular considerations such as offsets in serving a determining role in the negotiations. Commercial confidentiality was unwarrantedly claimed in respect of offset contracts, and the Auditor General and parliamentarians were prohibited details of the offset contracts on spurious excuses of commercial confidentiality. Sound advice from armed forces regarding their actual needs and prudent advice regarding the financial risks of the arms deal acquisitions were ignored. The South African Air Force, as early as July 1997, had informed the government that the BAE proposals were both unsuited to South Africa's requirements and were too expensive. The Secretary for Defence resigned in 1998 rather than be forced to take accounting responsibility for what he perceived as corrupt and unwarranted preference given to BAE.
Sir, it would be quite helpful if you were to deal with each of the elements. Like, if you deal with the element of fairness, say it was unfair because of the following, and then you proceed to the next element, and that transitional statement at least should be made, so that at the end, the Commission knows as to what is the basis of your assertion, what facts are you relying upon to assert that the procurement was not fair, it was not equitable, it was not transparent, it was not competitive, and it was not cost-effective. If we are to do it like that, at least it will be neat even for the purpose of the commissioners to understand as to what it was.
Sure. Okay, these 5 elements are fair. As I say, given the circumstances of the need for poverty eradication and the huge amounts that had been expended during the apartheid era, it was not fair for the new government to expend such huge amounts on armaments when we had so many other priorities. As regards equitable, it was quite apparent that there were all kinds of manipulated conclusions, that the warship contracts would go to the Germans and the warplane contracts would go to the British and the Swedes. Allocations would be provided to Italians for helicopters. And so these were backroom manipulations that really did not take these constitutional requirements into consideration.
My understanding of fairness in terms of provisions of the Constitution that quote relates to fairness, the fairness of the procedure, the acquisition process. Your testimony seems to suggest fairness of a different kind, unrelated to process.
So the emphasis of Advocate Budlander's opinion is whether the procurement process met the conditions of a system. And he finds, in his opinion, it did not meet the criteria of a system which was fair, equitable, transparent, competitive, and cost-effective. And so in that system, one of the considerations would be the requirements, for instance, of fairness in the circumstances that we faced where we had such huge socioeconomic issues.
My question relates to fairness in relation to the process. What we were saying seems to suggest that it was unfair because preference would have been given to social economic needs. That relates to need, not process.
Except, if you will, so the emphasis of the Defence White Paper had been that the country faced no foreign threat, but it did face the legacies of apartheid, and that needed to be the priority. And those urgent socio-economic needs were being discounted in favour of buying weapons, and consequently, as the affordability study would later point out, there was a crowding out of expenditure from those needs in favour of buying armaments for which there was no need for the country, given the fact that there was no conceivable threat to the country. So it was unfair socio-economically as well.
What was unfair in relation to the acquisition process?
I'm sorry?
What was unfair in relation to the acquisition process?
Well, it's unfair that there were considerations to drive the whole acquisition on the basis of the idea that if you spend 30 billion rand, you get 110 billion back, it's going to create 65,000 jobs. It was covered over by the idea of national security, when in fact the real threat to national security was the domestic legacies of poverty that we inherited from the apartheid era.
Maybe just one question from me, just from my own understanding. I heard you talking about the backroom manipulation as far as the evaluation of the various places were concerned. If that is so, which equipment type falls under that category? If all of them, can you just give us an example of as far as each of the equipment is concerned?
Yes, I would suggest all of them in different ways. The frigates had earlier failed the tendering requirements for engine requirements, specifications, and at one point even the Armed Corps Legal Department was suggesting that the frigate consortium should be excluded from consideration. There's then subsequently transpired that the combat suite was an issue, and also the gunnery was an issue. That's with the frigates. The submarines we'll come to later, that if we spent 6 billion rand on submarines from the German submarine consortium, we would get offsets with 30 billion to build a steel plant that was going to create 16,251 jobs. Of course, the steel plant never materialized. As far as BAE is concerned, there is a huge amount of discussion in the Commission about the idea of a non-costed option for the BAE contracts. As you recall, when former General Pierre Steyn was here, he was discussing that at some length. So that's one of those issues of unfair as well, and it comes in other areas when there's a lack of transparency. It's what is driving it. Why are we buying specifically warships from Germany, planes from Britain and Sweden, and Italian helicopters, irrespective of the technical specifications of the particular thing? For instance, the submarines, Germany came last in the military tendering criteria.
Mr. Brown, are you saying the entire evaluation process, there was backroom manipulation?
I regret that appears to be the case, yes.
Are you saying that is the case, or that appears to be the case? What is the answer?
I'll come, sir, to the question of the Joint Investigating Team report that followed the SCOPA public hearings in October 2000. And the JIT report was tabled in Parliament in November 2001 with an executive summary that purportedly exonerated the government from any malpractices. I have finished the Commission, in fact, with the draft of that JIT report, which finds that contrary to the public report that was tabled in Parliament in November 2001, there was massive irregularity in the tendering processes. And so that 741-page disc I've now provided the Commission for its own consideration and comparison against the public document.
Mr. Brown, can I go back to my question? My question is simple. Are you saying in that evaluation process that evaluation process and the various equipment types underwent? Was there manipulation? You say, well, was there any manipulation?
My answer, sir, would be yes.
Thank you. I suppose, those who want to deal with this issue, they can deal with it again at the later stage. Thank you.
Thank you, Chair.
That is from the Seriti Commission, and that's all we have for you here on AM News. From myself, Elvis Preslin, and Kendall Makamate, we'll be back same time, same place tomorrow, right here at 10 o'clock. Ciao for now.
I would like to bring it to your attention that Mr. Donaldson has testified before this commission. And in his testimony, part of what he did was to place the fiscus, the national fiscus for certain periods, where you would see the allocations that were made for the respective departments and respective projects by the national government. And what became apparent from those tables is that huge sums of money, not in terms of just monetary denominations, but even in terms of proportionate denominations, were actually allocated to the socio-economic groups in particular, and that was education, health, and housing. I'm not able to say off the top of my head as to in what order they were getting, that bulk, but it is a fact that has been presented to this commission with supporting tables. And those tables also indicate as to how much was being spent on the arms acquisition and also broadly on the Department of Defense, not only confined to the arms acquisition, the SDPPs in particular. Now, in the light of this information, is there anything that you'd like to say or would you like to comment? And maybe before you comment, it should also be